Julie Janae in Kentucky, and the first wife there, but the second wife not there. But the second wife, apparently, according to him, wasn't actually his second wife because she was married to somebody else when she married him. But the jury's not going to hear that she was convicted of bigamy because she has served her pretrial intervention and it's now been erased from her record. So she's no longer a convicted bigamist, although she was apparently married to two men at the same time. But the jury, I don't think, is going to hear that about her, that she's been convicted. There's a lot of storylines in this case, folks. What I'm not seeing, though, is a ton of evidence, unfortunately, for prosecutors. Let's bring in our think tank tonight, see what they have to say about all of it. In the Bronx, New York, criminal defense attorney Renee Hill is with us. In Atlanta, Georgia, family law attorney and law professor Randy Kessler. And in Houston, Texas, criminal defense attorney Carmen Rowe. Great to see you all tonight. I saw prosecutors, motive, and then I'm thinking, wait a minute. Not an element of any of the crimes. You don't have to prove it. It's great to have. It's like an extra, right? Renee, for prosecutors, the motive is like, is like a second serving, right? I finished my plate. Right. I'm going to get a second serving, so I pick up some motive on the way back. They're going to need a little bit more than motive here.
Yeah, the motive is usually like the nail in the coffin if they have that. It's the extra dressing, like you said. They're going to need more evidence in this case. And as I've had a chance to analyze it a little bit more, it seems like this is going to be a very tough case for the prosecution. There's a lot of missing evidence here.
Yeah, well, one thing they do have, though, Randy, and I like this because I've seen it in movies before, and it's extremely tragic, but I don't understand. The victim said, listen, if anything happens to me, Kit Martin's the one you got to tell police to look at Kit Martin. And I'm wondering, I mean, if you're to be at that point where you are so scared of someone that you think something can happen and you know who would be responsible, I wish there was a way for that person to take some steps to prevent it from happening. But that evidence is coming in. Do you think it's persuasive evidence that the jury will believe these people who come in and say, oh, yeah, the victim told me if anything happened, it was this guy?
I think it is going to be helpful to the jury. Like you said, we see it in movies, and we hear all the time about things like this, and everyone's thinking, I've got an enemy. And if you know somebody's out to get you, that's what we all would do. We'd say to our wife, to our spouse, to our best friend, look, if anything ever happens to me, I want you to know who did it. And we all hope that would get in front of a jury. Usually it doesn't get in front of a jury. It's interesting that they're letting it in, and I understand the theory. But yes, I think it's persuasive because you don't have anything else, right? I mean, your prosecutors, they don't have, like the defense said, there's no DNA, there's no eyewitness. What do you have? Dead men don't lie. Dead people don't lie. They spoke the truth, and you have to listen to them. There's something holy and sacred about what people say from the grave or before they died. So I think it's powerful.
All right, Carmen, let's get to the linchpin as described by the prosecutor, which is the shell casing, the .45 shell casing that was found. And Diana Phillips, the victim's sister, testified today, and she is the one who found it. Let's take a listen.
Did you discover an item on the back porch of your brother and sister-in-law's house?
Yes, ma'am.
Explain to us what you were doing on the back porch and how you discovered this item.
Okay. We had removed most of the personal items in the house. And so we were beginning to then work on areas where there wasn't personal items, i.e. furniture or jewelry or that kind of stuff. And so I was going through, they have this breezeway or back porch that is attached to the house. And so I was going through back porch, and I was looking for anything. Every time we go into that house, even still we own the house, I still look to see if there's anything that I could find of any relevance whatsoever. And that's what I was doing then. And so it was at that point in time that I actually then found what I now know to call a casing. At the time, I did not know the name of it.
Okay, Carmen Rowe, have you ever seen a case where the linchpin, the key piece of evidence, is found at the crime scene 5 months after the crime, not by investigators, but by a family member.
And on video. I just think this whole thing is way too convenient, especially when you know that this defendant was nothing but a suspect until this casing was found mysteriously 5 months later at the home. No one saw it, and then it matches his gun, allegedly, which I think there's some ballistic issues here that they're going to raise throughout this trial. But, you know, this is pretty surprising, and it's something that you can absolutely believe that somebody would plant to make sure that they get justice in this case.
Well, let's take a look at that video that you're mentioning, and we've got the video of Diana Phillips there at the house. Let's take a look at it, and you kind of see her. Now, when you zoom in, you can see in the reflection. If you look in the reflection, you can see her finding it. Look at that. The reflection of the door, you actually see her finding the shell casing. Randy Kessler, are you buying it?
Do you see her putting the shell casing down and picking it up? Because that's very convenient. I think it's she's believable to me. I think she's believable. But are you going to put someone away for the rest of their life based on that one piece of evidence? That's good corroboration. It's good, circumstantial evidence. But for that to be the linchpin of your case,
It's the linchpin.
no eyewitnesses. It is. That's a tough one. You've had stronger linchpins in cases you've tried, Vinny. I know.
Renee Hill, what do you think of the reflection, the reverse angle reflection of?
Yeah, you see her finding something. I'm not necessarily buying it, Vinny. This was the location.
She didn't even know what a casing was before,
scene.
Renee.
She didn't even know. So what? Come on, that's what she says. Come on, she says that she didn't know what it was. She didn't know the name of it. It's so convenient that she found it. Investigators were all over that property. This was an active crime scene. They were there. They did not locate the shell casing. Come on.
All right. Well,
not buying
we've
it.
got some skeptics here in the think tank. Let's take a look at what happened on cross-examination.
Do you remember giving the statement to the police?
I do, yes.
Okay. And now that you've had a chance to look at it, do you remember what you wrote in the statement?
I do.
Okay. Is it fair to say in that statement that you said, I was also specifically looking to see if any items might be evidence?
That's the second sentence.
Yes. I can read the first one too if you want me to.
Please.
Okay. I was afraid he was going to tell me I wasn't supposed to. The first sentence is, I was looking on the back porch to see what remained.
That would be the sorting part.
Okay. And then after the looking to see if any items might be evidence, you detail places you looked. Is that fair?
Yes, sir.
Okay.
All right, Carmen, let me ask you about the approach on cross-examination. It wasn't the searing cross-examination. It wasn't accusatory. But this is the witness, the family member, who found the linchpin, the key piece of evidence. Your thoughts about the approach to the cross-examination?
I wasn't impressed with the approach. I thought it could have been much more, precise about exactly what she was doing and leading up to it. I mean, again, the reflection, it looks like she's looking for something. I would talk about the convenience of some of that. And I don't know that they got into her motives potentially for finding such evidence conveniently on video, contacting, these authority figures before contacting law enforcement. I think all of that plays into, her credibility and to the motives, not to mention the fact that she couldn't pass a polygraph, which I know that's not coming in, but, I would work around that.
Not so loud the jury might hear you tonight, Carmen.
I know.
Renee, what would your approach be if you were trying this case in the Bronx?
The Bronx is a great place to try cases. But Vinny, I kind of like the approach of this defense attorney. I think that he's quite animated. I think that he's personable. And I think that he's luring her in a little bit. He's getting her comfortable with his line of questioning. Now, I didn't have an opportunity to see his cross-examination, but I feel like he was kind of lining her up to then hone in on the areas that he wants to go into. And like Carmen said, there's this polygraph that we know she failed. That's not going to go before the jury, but he can use that information to, line up the questions that he wants to put forth in front of this jury so that they can see that, what she has to say is really kind of coincidental, what she brings to this case. So I think that the cross is going to be extremely important and very beneficial to the defense.
Professor, let me ask you about the polygraph. Usually it's criminal defendants who either refuse or don't pass a polygraph. Here's a witness for the prosecution, so all of a sudden we got defense attorneys jumping up and down saying the polygraph should be in front of the jury, right? What are your thoughts about what those results really mean? Do you trust them?
No, I think everybody on this screen today knows polygraphs are subjective. It's based on who the tester is. And if you have 5 different people testing it, you're not going to get 5 consistent results. So, there's some subjectivity because it's a human being interpreting the responses and the reactions. But, thinking about that cross-examination, we're all thinking, God, there's so much he could have done. He could have said, aha, you thought, I've got it. I've got the silver bullet. You caught him. You're going to be able to put him away for life. But the one thing we learn in law school is you never ask a question that you don't know the answer to because you don't know if she's prepared for that and you don't want to be dramatic and look foolish. So I think he's done the right thing. He didn't have a chance to practice with her because it was not his witness. It was cross-examination. I think he's doing a good job.
All right, we'll see how it plays out. Trial will continue tomorrow. This one's going to take a few weeks. Again, a lot of layers to this whole thing, but not necessarily as much evidence as we see in a lot of other cases here on Court TV. All right, when we come back,